It is 9 minutes past 6 o'clock. Welcome to the show. You're listening to me, Gushwell Brooks, here on 91.9 FM. Wonderful to be in your company. And the one thing, to his credit, Al, our pal, always leaves an awesome track for me to kick off the show. And today it was, of course, none other than Phil Collins. I'm sure you guys enjoyed that one. I definitely did. I'm sitting here across from a very good friend of mine. We go back a few years. What, 23, 24 years?
23 years.
23 years,
23 years, yes.
Pull the mic closer to you.
Sure.
Because I got the deep voice, you got the Michael Jackson thing going.
Okay. Well. It's not what I was pushing for, but we got to play the cards we're dealt.
Anyway, sitting across from me is Advocate Zwelake Mahalamele, and we know him better as Zweli. So I hope that you don't mind if I refer to you. Because unfortunately in our world, we only have two, we only go by either advocate or counsel. So I hope you're not expecting that from me, because I haven't called you that in 23 years.
No, let's face it, I've been Zweli a lot longer to you than I've been advocate, so let's stick to the basics.
Brilliant, brilliant. So, as I said, Zweli is an advocate of the High Court as well, also a practicing advocate. And today what we will be discussing is bail conditions and everything attached to bail, just to give you a broader understanding. So, as I said in my throw forward with Al, our pal, was that if you're planning on getting into trouble, if you are in trouble, or if you have been in trouble, this is what the process entails. Alternatively, if you know someone that's in trouble, that's what we are discussing. But anyway, as I said, just going back very quickly, don't worry, it's not going to be a profile interview. We're not going to bore you with our histories and commonalities and all of those things. But Zweli and I, as I said, know each other from university days. I think it was my second year, your first year.
Yes.
Both of us at Wits at the time, and both of us studying law. And and our paths sort of converged at that point, and we became friends. And more importantly, we became friends, but also attached to that, we were also debating partners.
Correct. In several national and provincial events, which we did well in.
Which we did well in. And on that very note, very quickly, I just want to check in with Zweli if he remembers this one.
Oh, no. Off the bat, no.
Very quickly. Hey, let's go. Do you remember that one? We had T-shirts.
Yeah.
Hey, let's go kick ass.
No, oh yes, that was based on
Let's Fight in Love.
Yeah, Let's Fight in Love.
Let's Fight in Love.
That was yeah. Oh man, your memory's better than mine.
No, I thought about it, and I was actually wondering whatever happened to my T-shirt, my Let's Fight in Love T-shirt. Anyway, back to more serious matters. Get a hold of us on 084-221-2919 if you have any questions, any comments. You can send us a voice note. Alternatively, you can send us a text message, and we'll be happy to have the conversation there. Zweli's still having a giggle over the team Let's Fight in Love. We had T-shirts made, guys.
Yeah, we also, I should point out, had anime characters that we assigned ourselves from a show called Naruto.
Yes.
And I believe you were Sasuke, right?
Sasuke,
Sasuke, and I was Gara of the Hidden Village of the Sand.
Exactly.
But anyway, I promise we were cool.
We were cool. We made it to the semi-final together, and we did pretty well back then.
Yeah.
But getting on to the topic of discussion tonight, Zweli, I think let's start off by defining what is bail.
Right. I think the best way to explain bail is to talk about the inherent rights we all have as South Africans first. Now, bail exists because in terms of the Constitution, Section 35 of the Constitution, we have an inherent right to our liberty and freedom. And it's something that is enshrined in our Constitution for two main reasons. One being that we are presumed, not usually, always, presumed innocent until proven guilty, which is a common principle around the world. And the second is that the Constitution is a document that sort of tries to redress some wrongs of the past, which include people being arrested for no good reason or being held in captivity for longer than they should be. So that right is very strong in our Constitution. Now, what that means is that when the state takes a person into custody, the default position is that that person is allowed to be freed until such time as they are convicted of a crime. And so I like to define the levels, the gates the state uses to test whether that person should be let go or should be held behind bars as 3 gates.
Okay.
People talk about schedules 1 to 6,
Yeah.
but I like to talk about 3 gates because schedules 1 to 4, in the case of schedules 1 to 4, the likelihood is that you'll get bail. These are sort of lesser crimes. They're not lesser crimes, but the likelihood is that you haven't committed them to the extent that the state would want to keep you behind bars.
Okay.
And then once you get to Schedule 5 and 6, these are your heavier crimes, your aggravated assaults, your rape, murder, etc., high treason, and so forth. And so what the state does is it creates these 3 gates that essentially apply to Schedules 1 to 4.
So before you continue there, I think let's also just define what, or just, you know, we don't have to go through the entire extensive list of what specific crimes fit in which schedule from 1 to 4.
Sure.
But if you don't mind just taking us through some typical examples of those 1 to 4 schedule crimes.
Right. So 1 to 4 scheduled crimes are illegal possession of drugs or alcohol, or for instance, petty theft or breaking and entering, and so forth. The difference comes when you consider schedules 1 to 4 versus schedules 5 and 6 is the severity of the crime committed, because an assault can be a slap to the face, but it can also be something that puts you in a coma in the hospital with several stab wounds.
Yeah.
Now, both of these are assaults, but one would be more likely to fall under schedules 1 to 4, and one would be schedule 5 and above. And so what I think the key differentiator between schedules 1 to 4 and 5 and 6 is that the onus shifts when you get to schedules 5 to 6. So to go back to the point I was making earlier, in the beginning, the state is under the obligation to prove that you need to remain behind bars, because the assumption based on our constitutional rights is that you get to go free.
Sure.
So you get bail. But if you commit a crime in terms of Schedule 5 or 6, then you have the onus to show that there are exceptional circumstances that warrant that you should be let go on bail, even though the assumption is that you shouldn't. So the key critical issue is that from Schedules 1 to 4, the onus is on the state to say, Zweli can't go home because we recognize his right, but it's in the interest of justice that he stays. But for 5 and 6, it's more I did the crime, but I can show exceptional circumstances why, even though I did that crime, or
I'm accused of
that crime. Thank you for the clarity.
Sure.
I should be allowed to go home. That's the big differentiating factor.
Fair enough, because Schedule 5 and 6, the crimes that you've been accused of are of such a severe nature that it's not only that you perhaps pose a danger to society, but society itself actually poses a danger to you. By way of example, I mean, there's a couple of those.
Yeah, I mean, I think you touch on something important. Sometimes society obviously poses a danger to you, and so even in the cases of Schedules 1 to 4, people may elect not to make an application for bail precisely for that reason. But yes, ordinarily it would be for more serious crimes, Schedules 5 and 6 and so on.
And a good example that comes to mind immediately is it's common theft. It's a petty theft, but theft is so prevalent in a particular community. People are so dingusful of crime that vigilante action might be a common thing.
Exactly.
And so even if this person who has not been proven to be guilty of theft is let out on bail, there's a probability that the community might even turn on him.
Precisely.
And exact, a bit of street justice, for lack of a better term, on that person. So it becomes quite complex. But Zweli, I thought also in this conversation that there's also a beginning point to this, right? And there's usually that that an arrest is affected, right? So you are arrested
Correct.
by a police official or peace officer, and then you usually taken to a police station where you are then processed, and certain things happen, charged, and we go from the process there. And there's obviously various categories, different places at which you can actually obtain bail.
Right.
I think let's start unpacking that.
Sure.
What is this thing called police bail?
Sure. So this is where I go back to the gates that the state uses,
Sure.
and the gates you have to get past to get out of custody. The first gate is police bail. The second gate is bail by way of the prosecution, and the third is going to court to apply for bail.
Wow. Okay.
So the easiest gate is police bail. Now, what is police bail? Police bail is an instance where you've committed an offence in terms of in terms of the schedules, but it's of such a I don't want to say minute, but of a less serious nature. So, for instance, you've been found in possession of an illegal substance. But
let me also jump in there just to clarify for audience as well. Look, I think within the context of this conversation, we will be talking about minor and major offences. And that does not ever underscore or undermine whatever experience you may have had with crime. Crime is always a serious issue. It's always a severe issue, and we recognize that. Absolutely. I think what the point is for this particular conversation is we need to differentiate between common assault, say the slap to the face, versus mass murder.
Right.
There's a clear difference between the two. Right. And we can't equate.
Or even more severe assault.
Yeah. Exactly. We can't equate the two. Or even severe assault. I mean, that example that you gave of a slap to the face versus
being stabbed.
Being stabbed and beaten to an inch of your life and literally lying in hospital in a coma. Those are two very different, situations, even though it, for lack of a better term, falls under the same criminal category. So the point that we're making is, and I get what the difficulty is that yes, it is difficult to sometimes delineate between these minor and major crimes, but for this conversation, we are going to make reference to major and minor crimes. Right. Sorry, I interrupted you there.
No, I think it's a good clarification to make. I think the clarification is for technical purposes, not because there is any less severity for the victim.
Or we flippant about the thing.
Exactly. Just in the case of police bail, what we mean by minor is sort of in the case of, say, possession of an illegal substance, we're talking about something maybe in your pocket, a joint in your pocket, something like that, versus, for instance, 50 kilos of an illegal substance. You see, that's what can make that distinction between
the two. That a certain police official on the Madlanga Commission claimed that he could smell. He could smell cocaine.
Yeah, we'll see how deep we get into that. There's a good example of a police sergeant who's recently been disallowed bail for what could be argued to be Schedule 1 to 4. So
I tell you,
we'll get there. But
we'll get there just before the show ends, I promise you. Yeah, we'll definitely touch on that.
What we're talking about in the case of police bail is your minor offences, where you have, where you are alleged to have committed a crime. But the nature is such that a police officer, in consultation with the investigating officer, might themselves be able to provide you with bail.
So, under those circumstances, look, let's be quite frank. A lot of people get picked up for minor offences. It could be the way that they drove, the condition under which they drove.
Right.
So a typical example of where you could obtain police bail is, for example, drunken driving, right?
Right.
So you get pulled over, you blow into the breathalyzer, you're above the limit. They should take you to the police station where a trained medical practitioner then obviously extracts blood for the purpose of evidence at a later stage, etc., etc. Once all of that stuff is done, you should be able to obtain police bail.
Yes.
Where the confusion comes in, and this is a personal gripe of mine, is to clarify, where does this bail get paid and to whom? Does it, for example, can the arresting officer who's a mere constable in uniform, then say to you, Gushwell, you pay your bail to me. Your bail is 500 rand, 1,000 rand, 5,000 rand, whatever amount comes up, right?
Sure.
And then you hand over said amount of money, but it has to be in cash, or
Yes.
you know.
In fact, it does. It's legislated that
Sure.
it has to be cash. Yeah.
Brilliant. It has to be cash, but or alternatively, you can do an e-wallet to my number. Or you hand over the cash, and then the cash doesn't go to, into the till, it goes into someone's pocket.
Yeah.
Is that bail?
So I think the thing to clarify is that when it comes to police bail, it has to be cash, number one. And it's not so much about the payment method. The legislation says cash, but the legislation also says you need to be provided with a document that indicates when you'll be appearing, the court and so forth, as well as that document needs to reflect the amount that you paid in bail, so that at a later stage you can get that money back. And I think that's where sometimes there's a bit of an issue, because a person may pay an amount and not get the full amount back, or something like that happens. And this is why it's critical that the legislation asks for a receipt for that payment.
So in other words, there must be a receipt.
Yes, it's part of the.
I take it, and I know that we very under-resourced in this country in certain parts, but presumably it's an office or something that looks like an office. It probably gets put into a little cash box. Remember those old metallic cash boxes that people would lock and unlock, put the money in and close, and then hand you. And the receipt needs to be somehow official.
Exactly.
It can't just be I, Sergeant Sipo, John, whoever, hereby confirm that I got an amount of money from Zweli as bail.
No, the Procedure Act asks for a specific document that outlines how much you paid, and also outlines when you're supposed to be in court and the rest of that. So, and it's the same document you would use to claim back your funds at a later date after the proceedings. So it's an essential thing. I mean, that's the only way to really control it, because it's cash, because you might e-wallet or what the case may be. The only way to prove that you paid the money is to present a document, a receipt of that payment.
So you made, and let's touch on this very quickly before we move on to the other two categories of bail. You mentioned prosecutorial bail as well as bail that then is set within court, right? But I thought I need to touch on this issue because you kept on making mention of the fact that you could get your money back, and in fact that you need that very official receipt for you to claim your money back. Under what circumstances do you get your money back? If you get convicted, sorry brother, you have, or sister, or whoever, you have forfeited that money to the state, or under what circumstances do you get your bail back?
You get your, well, no, I mean, it's not a question of conviction or not. See, bail is about guaranteeing your attendance to court. So it's something that you can claim back regardless of the outcome. That's a separate matter. Your trial is a separate matter. Bail is something that we use to guarantee your attendance at court. And so you forfeit it by not attending, as you said that you would, for your actual trial. Remember, when we do bail proceedings, the assumption is that you're innocent. There is no conviction against you. So what we use bail for is to guarantee your attendance. And so therefore, it's not something that you forfeit because of a pronouncement by another court.
That's brilliant. That's actually, I find it fascinating. So, in other words, you could end up, in other words, you could be found not guilty and still lose your bail because you failed to pitch up in court.
Exactly, yeah.
Yeah, because you were supposed to appear on the 14th of May and, I don't know, you forgot, or you just didn't feel like it, or you had a job interview, or whatever the case may be, and so you didn't go to court. And on that basis, you could then forfeit your bail and still be found not guilty of the actual offense that you are, the underpinning offense that you've been charged with initially. Or alternatively, you could be found guilty and sent and given a life sentence and still get your bail money back.
Yeah, I mean, essentially. I think the thing to remember as well is that by not attending court, you may be opening yourself up to a further offense.
No, of course, yeah.
And so, and so that in itself may be, a crime, because a warrant has to now be issued for your arrest because you haven't been able to pitch up to court.
Yeah, they're going to issue that warrant. The point of it, the point of it is, the point is that it's a security deposit. This is I'm leaving this money here, and I'm coming back for this money because I'm at court every single time I need to appear. 084 221 2919. That's where you send your WhatsApps, your text messages, whether it be a text message, alternatively a voice note. If you have any questions on this particular issue, I think the one thing that you have taken away from this conversation is that bail is not the money that you hand over to said police official that goes into their pocket. It actually goes into some official place, and you get an official piece of paper indicating how much you paid, more importantly, on what day you need to appear in court. Welcome back. It is 22 minutes to go before we get to 7 o'clock. And you are with me and Zweli, better known as Team Fighting Love.
Let's fight in love.
And we're talking about bail. And what is bail? What does it mean? And the one bit that we're going to touch on, of course, we've explained why bail exists. It's number one, you are presumed innocent until proven guilty. So where the circumstances allow, you're allowed to obviously go home and live your life and do your work, etc., etc. But you need to come back to court. And that is why you should see bail then as a security deposit, for lack of a better term. Because if you fail to come to court, then yes, you will forfeit your bail and you will face further charges. But the main thrust behind it is to say that guarantees your return to court. Now, Zweli, we've spoken about police bail. Let's get on to the other two forms of bail, and that is prosecutorial bail as well as court bail. Prosecutorial bail, what's that?
So prosecutorial is a slightly higher level version of police bail in that the person who can provide you with bail is the prosecutor now, at the direction of the Director of Public Prosecutions. So what that implies is the same sort of crimes, so your lesser crimes, but also more technical in nature, where you need some sort of more technical legal understanding to make the decision whether or not this person can go home now, or if they need to go to court and make a formal application. So I think let's stick with the one example. So you're in possession of maybe a bankie or a bankie or two or something like that. Now there's a bit of a uncertainty as to whether or not you fall into.
So what Zweli's talking about here is possession of an illegal substance or a substance that you're not allowed to have on you.
Yes.
So in this instance, and this is something that people still need to sort of wrap their heads around. Even though you're allowed to use marijuana in the privacy of your own home, you can't just carry it with you everywhere and anywhere you go. Precisely, you're not allowed to purchase it. You need to
deal it.
Or deal it. You need to be growing it yourself. It can get quite technical. But the point is, then there's a further technicality where if you have a certain, I can't remember the grammage, but if you have a certain number of grams and below, it's merely a possession charge. However, if you have that grammage and above, it could be possession with intent to distribute.
Exactly. And then you ask yourself, well, does this fall into schedules 1 to 4 or 5? In which case the onus flips, you see, and now you need a legal mind to examine the facts, at least to some extent, before providing the bail. Now,
no, I'm sorry for laughing, but it's a memory. It's a memory that hit me. Someone that we knew.
Are you sure you want to make an admission like that?
No, not my admission. It's someone that we knew in common, and I'm just thinking, I wonder. He had a knack for being caught with certain things, and if he ever found himself in that position, that's why I childishly laughed there.
Yeah.
But I mean, it's a very valuable point to make there. So in other words, it's not just for the Bobby on the beat to then make the
to make the call.
Police station,
yeah, and that's really the main distinction. If you're looking at police or prosecutorial bail, you're still these are easier gates to get through. The main issue is the next one, where you have to appear in court. And that's what we see most of the news. Most of the news and the things we see in the media are bail applications. And those can only happen in court in front of a presiding officer, magistrate, or a judge, as the case may be.
So let's touch on that. So, you made reference to the Constitution, and we get this constitutional principle that within 48 hours of my arrest, I have a right to appear before a judicial officer in a court.
Correct.
Right? So that being a judge or a magistrate.
Correct.
Do I then automatically have a right to a bail hearing? Because I've been to the magistrate's court, which to many different magistrates' courts, and
Correct.
I've seen those first appearances, and all too often, for lack of a better term, it's almost checking the register, making sure that this is so and so, this is what they've been charged with, thank you very much for coming, postponed to such and such a date.
Correct.
And I always wondered to myself, what if that individual who's been charged with common theft, common assault, nothing major, would have liked to have applied for bail?
Right.
And they were literally just called up, sort of confirm your identity. This is what you're charged with. Thank you for coming. Please go back into custody. By the way, are you therefore then entitled at that 48-hour first appearance to apply for bail?
So yes, the law says that you are allowed to apply for that bail, but whether you'll be heard on that application at your first appearance is the problem that I think you're alluding to now. And the reality is that South African courts are inundated with all sorts of applications and so on. And my time as a working with defences in trial courts, the waiting periods would sometimes be ridiculous. You're talking about 6 weeks or and the like before being heard for your trial. These days, people will set trial dates. Let's say there's an offence and they want to set a trial date. If it's 2026 now you're looking at 2027 late or 2028.
Jeez, mate, you talk about this in the news. I heard that the Jacob Zuma-Talis matter, the arms deal case.
Yes.
For the former president. The trial date has been set, but for February 2027.
Exactly.
After the judge expressed great frustration at the fact that this matter has taken so long to resolve.
Exactly.
And lo and behold, it's only going to trial in February 2027. And hopefully it does happen by then.
Yeah.
Because then hopefully there's not some other interlocutory application in between that then kicks it further down the road. Down the road, yeah.
So, and I think that's the unfortunate issue, is that you do have a right to make that application as and when you make your first appearance. But the state, because it is also an administrative body, can ask for a postponement, either because they have a gigantic backlog or because they don't have the evidence to argue the matter, and so forth.
Or realistically, the prosecutor only received the docket that morning.
Yeah, I've worked with a lot of colleagues who would say, you pitch up as the defense, and there's on their desk is about 40 dockets that they have to get through. So that has more to do with administration. I think if the courts were more empty, then you'd have more bail hearings quicker. But what happens is, bail gets kicked down the road for actual trials that may have, been waiting for, I think we've demonstrated for years in some cases.
Yeah.
And that's the big problem. And the other side of that, the other thing about that is that, after your first appearance, you get to make the law requires you to be able to have another chance to make that application within 7 days.
Okay.
So and this is what happens a lot. People try to make the application, they get postponed. 7 days later, they're back, get postponed, and so on. Because realistically, we're talking about your application's a month away, and the like. But that is more to do with administration and where you are, which magistrate you're in, how many cases they have to deal with, and that kind of thing.
But a key point, and something that I appreciate you mentioning there, it's an application. And an application is almost we should see it as a separate action in court. So even though you've been charged with this particular crime, that application, that bail application, for lack of a better term, in a very layman's understanding of it, is a separate court process. It's a separate case that has to be
Absolutely.
heard. It's an application, and then the judge has to apply their mind, or the magistrate has to apply their mind, and then decide whether the person gets bail or not. Now, in the US, all too often, bail is set at ridiculous amounts, $7 million US.
Yeah. Yeah.
But the guy works at a McDonald's.
Yeah.
And there's no way he's ever going to be able to afford $7 million US, right?
Yeah.
Or, it's, in South Africa, whereas in South Africa, I mean, some people that, are up for bribery and corruption charges worth millions and billions get 20,000 and 50,000 in bail.
Right.
If you go to a magistrate's court tomorrow, people with some serious charges who eventually do get bail don't have to pay a cent. They get let out on warning, what we call, warning.
Sure.
And colloquially is referred to as free bail.
Sure.
So explain that to me, the economics behind that.
Yeah, I want to do that, but I just want to make this point before we get there, which is that the purpose behind bail we must remember that the purpose behind bail is to ascertain whether or not you would be a detriment to the main trial, the main investigation against you, and the trial that results from that investigation.
Sure.
So the biggest question that the prosecution has to answer, or the state has to answer, is: are you going to, in some way, be obstructive of justice if we let you go?
Yeah.
That's the biggest question, right? And coupled to that is how severe is the crime that you've committed. Now, the severity of the crime, as will dictate the thresholds for the amount of money that you will have to pay. So if you're in the 5 or Schedule 5 and 6 category, now you're talking about bail in the tens of thousands or hundreds of thousands. But if you're talking about your petty crimes, you're talking about between 500 and 5,000 rand, right? But even if your bail, even if the crime itself is one that only relates to an amount of, say, 5 to 5,000 rand, you may still not get bail because you are a significant threat to the interests of justice. And this is where this funny Nkosi matter comes into the fore. Like, it wasn't really so much about whether he had the 10,000 or not.
You're itching to say that. Go for it.
Yeah, well, I mean, I'm fascinated by this particular application because it's a great demonstration of what actually matters in a bail application.
I get you, yeah.
And what actually matters is how likely you are to influence the investigative process and the trial process that comes later. And that's what his team failed on. The concern there was that, because there was, police dockets found at his place and so on, that they and because he's a sergeant in the police and arguably has contacts and so on, that he could perhaps influence the investigative process and so forth. To me, and of course I must say I'm an outsider looking in, but to me that seemed to be the key issue. Not whether it was going to be 10,000 or less or more or the like. But I think they struggled to show that he would not in any way hinder the investigative process if he was let go.
It's very difficult to prove that you're not going to hinder the investigative process if you're sitting with police dockets in your house.
And you're law enforcement.
And you in law enforcement.
Yeah.
And if I'm not mistaken, I did an opinion piece on that, by the way, for those of you that want to go check it out. Remember I told you I'm only on 3 social media. What used to be called Twitter is now called X. I'm not very active there, just put out the stuff that I do. Facebook as well as LinkedIn, because I'm a grown-up now. So hashtag Legal Lifeline. Look for that hashtag. That's where you're going to find me. If you scroll through it, you'll see that there's an opinion piece that I wrote about the swathe of arrests that we've seen recently, and I do muse a little bit about the fate of Shame, poor Fani Nkosi. He had a rough time though, eh? I feel for the brother. But at the same time, like, hey, you said his team let him down. I think.
I want to retract that. I'm sure his team did the best that it could. No, but in our circles, that may mean something. I think they had a tough proposition to fight against. In that, if you are a member of law enforcement and if you are found with documents that obstruct justice in your possession, it becomes very difficult to say that in a matter where your own life or your own career is at stake, that you may not be involved in the same kind of activity.
But my learned colleague, this is where, if we were in court, I would say the client has instructed me. The client has instructed me. Because even though, not a snowball's charged in hell, the client instructed me. Look, I mean, but the other point I think that we also have to raise is that bail is not punitive in nature, unlike in the American system, where there's almost a punitive element to it. And that's why a McDonald's worker, for example, would be given bail of $7 million US. But here, where you would assume someone should be given a really hefty amount, instead gets, say, 5,000 Rand bail for murder, assuming that they were able to prove that they're not a danger and they're not going to impact the investigation, and that the exceptional circumstances exist for them to get bail, that an amount as little as 5,000 Rand could be applied because the person may be what we call in law, and we have some problematic terms in law, like a man of straw, right?
Yes.
He's a man of straw, he doesn't have a great income, he might be unemployed, etc. Or even what we refer to in very rare and exceptional circumstances, free bail, if the person is let out on warning.
Yeah.
And that warning is, if you don't come back to court for your future court dates, an arrest warrant will be issued.
Correct, yeah.
So let's touch on, I think, the final issue that we have time for, looking at the amount of time that we have left. Zweli, there's this, I consume a lot of news, and all too often someone gets bail, they charge with something severe and serious, and then the person gets bail. From Katiso Molefe, that to the extent that it even went as far as our current judge president was implicated.
Yeah.
With claims of him, he could have only given this guy bail because of a bribe, etc., etc. But the point is, it's almost as if people see it as a sign of innocence. If someone gets bail, it means that the innocent in the state, the NPA, the useless NPA, is going to lose the case, etc., etc. That's the commentary that we hear, not my words. The commentary that we hear. How do we view that? If someone gets bail, is that a clap and a win for the defense and for the accused?
Not beyond being able to establish that the accused will show up for trial. The only purpose of bail is to ascertain whether or not it would be a good idea to let this person go, and if they'll come back if we let them go. And I want to emphasize this because even when you get up to the highest, your Schedule 5 and Schedule 6 crimes, while the onus rests on you, it's not impossible for you to get bail even in those instances, because remember, the only question is whether you will obstruct the investigative process or be a danger to society and the like, right? And so the onus just becomes very difficult if you've put someone in the hospital in a severe condition to get bail. But you might still be able to. Or if you're living
with the witness, with the complainant.
Precisely. Yeah. So, but it's still possible because, as I said, it has nothing to do with whether or not you are innocent or guilty. And in fact, the state assumes you're innocent. The reason they might deprive you is because they want to control your movements up until and including the investigative process. And so even if you have a Schedule 6 crime that you've committed, if you can demonstrate exceptional circumstances, you can, even in that situation, possibly get bail. And it's important to remember that when the court considers this, it considers those factors as well as let's assume you're the primary caregiver for a child. The interests of that child are also brought in and can be argued to be a reason for you to be out, even in a very serious offense. Then you have to show that once we let you out, besides taking care of that child, that you're not going to do anything to jeopardize the state's investigation against you.
On that very point, a very prominent member of parliament, leader of one of our major opposition parties, recently has been convicted of a crime. I think given a 5-year custodial sentence.
That's correct, yeah.
He obviously then and there launched an appeal. And he got to sleep in his bed that night.
Yes.
With bail. So in other words, bail can still apply even with a guilty verdict. The point is that he's been found guilty, yes, in a particular court, in the lower court, and now he's appealed to a higher court, and it's up to that higher court to then decide whether this.
Well, because he hasn't been sentenced yet, so you know, or in a sense that's the point of contention there.
Because he's appealing the sentence.
Yeah.
No.
Well,
Not the sentence.
not the finding, the conviction.
The actual conviction.
And just on that point, I want to make the point as well that even if the court makes a finding on bail, let's say they deny you bail, you can also appeal that to a higher court, before the trial proceedings are launched against you. And so you may find...
Would that ever be an urgent application? Because, I mean, I'm in jail now. I've applied for bail. I've been turned down for bail. And I want to go home, clearly, and I want to go home now. So, obviously you have to prove urgency in the higher court.
Exactly.
Which is not an easy thing to do.
Which is not an easy thing to do.
But would it be an urgent application?
Now you're asking me something that
A deep one.
Yeah, I would say...
Let's do what other counsel do. We shall stand the matter down. And we shall debate. Look, we'll have to stand the matter down anyway because there's literally 2 minutes left in the show. And up next is Zweli. I hate saying this. You're a brother to me. We're really close, but the coolest attorney that I know, man. He's coming up next. Michael Timvios, the Rock Roadhouse. I'm definitely looking forward to listening to that as I'm driving home. Anyway, guys, it's bye from Team Fighting Love. Thank you so much. This was so awesome having you in studio and doing this. And we should do it again.
Yeah, I'm happy to help, and thank you for having me on the show. It's been a really pleasant experience.
Jeez, this is where people walk out and start discussing podcasts. Only the millionth and first one to be launched. Fighting love. All the best until next week. Really looking forward to it, guys. This was a fun one. And not to say the others weren't, but this one was particularly special. Anyway, looking forward to chatting to you then. And Michael Timvios up next.